The suspect in the botched airliner bombing is being treated as a criminal defendant, not as an alleged enemy combatant. That means a trial in federal court with all its various legal protections instead of interrogation by the U.S. military. The administration's decision on how to handle this case is already sparking lots of controversy. Brian Todd has been looking into this for us. So what are you finding out, Brian?
Well, the suspect is now facing 2 federal charges, each carrying a maximum sentence of 20 years in prison. A law enforcement official would not discuss with us today whether more charges might be brought against him, but there is a real controversy now over the fact that he's even in the civilian justice system. He sits in a federal penitentiary in Milan, Michigan, charged by the U.S. government with attempting to destroy an aircraft. To some in Washington, that's the problem.
If we had treated the Christmas Day bomber as a terrorist, he would have immediately been interrogated military style rather than given the rights of an American in lawyers. We've probably lost valuable information.
Another senator, Homeland Security Chairman Joe Lieberman, calls it a very serious mistake for the administration to place Umar Farouk Abdulmutallab under civilian criminal charges rather than treat him as an enemy combatant. Lieberman argues Abdulmutallab committed an act of war and should be interrogated like a military prisoner, so another possibly imminent attack can be quickly prevented. The president's top counterterror advisor aggressively defends the decision to go the civilian route.
We have great confidence in the FBI and other individuals in terms of debriefing. We have great confidence in our court system so that we can use that to our advantage. And individuals in the past have, in fact, given us very valuable information as they've gone through the plea agreement process.
Contacted by CNN, a U.S. law enforcement official would not say whether a plea bargain is being discussed for Abdulmutallab or not. Former White House Associate Counsel David Rivkin argues the problem with offering him a plea bargain is crucial time lost in setting it all up. What could the military system produce that the civilian system could not produce in this case?
The short answer, it can produce things faster and better. Faster first because you do not have access to counsel. You do not have Miranda warnings. You do not have people, in effect, telling you to clam up.
Rivkin says Abdulmutallab's lawyers could drag this process out for months while they strike a deal. The suspect has at least one public defender. The law enforcement official we spoke to would not say whether he's cooperating or if he was read his Miranda rights. Absolutely. Eugene Fidel, who's tried several military and civilian cases, says the administration's made the right move.
Choosing a military forum rather than a civilian forum is not going to make any difference in terms of the speed with which you could extract information from a suspect. In fact, the rules are going to be the same in both forums. And there are indications that Abdulmutallab gave some information to U.S. officials very early on in this process. A law enforcement bulletin obtained by CNN the night of the attempted bombing says the subject is claiming to have extremist affiliation and that the device was acquired in Yemen along with instructions as to when it should be used. Wolf, on that very night, he spoke to someone, some U.S. officials, and gave some information.
Yeah, but he was wounded. He had just been burnt in that incident, so we don't know how reliable that information was. Given all the eyewitnesses that were aboard that plane, the forensic evidence, conviction probably is not going to be at issue, but getting intelligence quickly could be at issue.
That's the real issue here. That's why so many people are up in arms about the fact that he's in the civilian system. But the criminal conviction, I mean, you can cite examples, and John Brennan cited 4 examples, we'll give them to you here, of terrorist convictions in a U.S. civilian court. The shoe bomber Richard Reed, a case that has a lot of similarities to this case, obviously. 9/11 conspirator Zacarias Moussaoui. Ayman Farouz, a former truck driver convicted of providing material support to al-Qaeda for his role in a plot to destroy the Brooklyn Bridge. And we all know the case of Jose Padilla. He was held as an enemy combatant for a while, then transferred into the civilian court system, convicted of conspiring to kill people in an overseas jihad and also funding and supporting overseas terrorism. 4 key convictions there that U.S. officials are now pointing to, saying this system works well.
Brian, thanks very much. So should Umar Farouk Abdulmutallab have the same rights as an American citizen? Let's bring in our senior legal analyst, Jeffrey Toobin, a former assistant U.S. attorney himself. Looking back at this, should he be tried in a civilian court or as an enemy combatant?
Boy, it sure seems like the Obama administration made the right call here. mostly because military tribunals have not been used successfully in a terrorism case since World War II. This legal system is untried. It is unclear whether the Supreme Court or other federal courts will uphold any judgment in a military tribunal. That system is completely untested, whereas in the criminal justice system, the federal criminal courts, the district courts, we know how it works. Richard Reed, who committed an almost identical crime, was tried entirely successfully, pled guilty in 2003. I don't understand why this situation isn't identical to the Reed case.
The argument being that actionable intelligence could be lost if you let some public defender, a criminal defense attorney get in, lawyer him up. He's not going to cooperate.
Well, you can't torture someone. You can't interrogate someone against their will in a military tribunal case. I don't understand exactly what the critics think would happen that would be different. Presumably, we have learned that waterboarding is not a good idea, so they're not suggesting that. But the differences in interrogation between the current conception of military tribunals and federal district court are not really that big. So I don't see what kind of advantage you would get in terms of interrogation, but you would have the big disadvantage of an untested and uncertain legal future in the military tribunal.
Now, what about this notion of a plea bargain, that he could get a lighter sentence if he came clean, cooperated with federal authorities? What do you think about that possibility?
Well, I think it's a pretty remote possibility. This is a life in prison case. It can't be a death penalty case because fortunately no one died. He's not eligible for the death penalty. But Richard Reed is serving life without parole. I can't imagine this case will end any differently than that. So I don't think there is a lot of room for a plea bargain. You could talk about, whether he'd have access to family and see his relatives. But by and large, this case is not one that's going to be susceptible to plea bargaining. So I don't think that's really going to figure in very prominently in this case.
We're now learning, Jeffrey, that there's going to be a hearing on Friday for Abdul Muttalib to see whether he stays in jail or presumably is eligible for some sort of bail. You're smiling.
I'm smiling because I would say the chances of this gentleman getting out on bail are beyond remote. This is a routine practice. A certain number of days after someone is imprisoned in federal court, you are entitled to what's called a detention hearing, where you can raise the issue of bail. But there is no chance in the world any judge in America will release this guy on bail. So this hearing on Friday, if it takes place at all, will be purely a formality.
Good point, Jeff. As usual, thanks very much.
Okay, well.